Welcome to the latest Work Foundation event, which today is focused on the implications for employers and employees of the forthcoming Employment Rights Act. My name is Ben Harrison. I'm Director of the Work Foundation, a research and policy think tank, which is part of Lancaster University. We are committed to supporting everyone to access well-paid and secure employment, and our current work programme is particularly focused on job insecurity for those who face structural disadvantage within the labour market, the challenges facing young people in accessing work, and the interrelationship between health and work. Now, of course, as I'm sure everyone who's on the call today knows, delivering a new Employment Rights Act was one of the government's flagship manifesto commitments. And of course, the passing of the bill dominated quite a lot of political discourse and newspaper column inches, particularly during the run-up to Christmas 2025. Quite late in the day, key elements of the bill appeared somewhat uncertain, and there remains some significant elements still to be fully fleshed out through consultations, new codes of practice, and secondary legislation. Of course, the Act itself is broad, and it's going to introduce significant changes in a whole host of areas across a phased timeline, beginning in just a few short months. And so we wanted to use the session today to first lay out and then explore the big changes that we're expecting to see, as well as what is still to be resolved during 2026. To help us do that, my colleague George Williams will shortly give an introductory presentation which covers the main elements of the Act. I'm then delighted to be joined by a fantastic panel of speakers who will help us navigate in a bit more detail what the implications of the different elements of the Act are likely to be. They are Claire Burns, People Director at textile company Abraham Moon, Laura McFadden, a partner at Stephen Scone, LLP, Samson Lowe, Head of Policy at Unison, and Alice Martin, Head of Research here at the Work Foundation. In terms of housekeeping for the session itself, because of the breadth of the Act and the immediacy of some of the changes, we're going to try and focus the conversation today on those elements explicitly arriving in 2026, or those that require kind of urgent preparation during the next calendar year. We aim to hold further sessions later in the year to explore those bits of the Act that come into force in 2027 and beyond in a bit more detail. We also want the session today to be as useful for all of you dialing in as it can be. So during our initial presentation, please do use the chat function to say what you're most hoping to get from the event today. And I'll try my best to use that to inform some of the issues we cover through the conversation. During the panel discussion itself, please use the Q&A function to table specific questions for our experts. I can't promise we'll be able to cover them all, but I will do my best. And if we can't get to them during the main discussion, colleagues will either be attempting to respond direct in the Q&A tab, or failing that, we'll do our best to follow up any outstanding questions post the event. And just to say that George's slides will be shared, and they do feature some links to additional resources that you might find useful. Finally, this session is going to be running through to 3:15, which I think is a bit shorter than the original time we shared, so we're giving you back a little bit of your afternoon. With all of that said then, I'm now going to hand over to George. He'll get us started by laying out the key elements of the Employment Rights Act, and then we'll get into the wider discussion.
Great, thanks, Ben. Hi, everyone. Thank you all for being here today. As Ben was saying, I'm going to get my slides up. This presentation will look at the Employment Rights Act, and in particular, sort of the measures that are going to be coming into force during 2026. So as a bit of an overview of the Act itself, the ERA, or the Employment Rights Act, became law in December 2025. It represents the most substantial update to employment law in a generation, with some of the more headline-grabbing measures, including the banning of exploitative zero-hours contracts, day one rights for sick pay, parental leave, and protection from harassment, and the enhancement of rights of trade unions, and protections from unfair dismissal after 6 months. So the ERA could substantially improve the lives of workers across the UK. Research by the Work Foundation estimated what levels of job security would have been in 2023 had 2 key reforms in the Act been in place, those being protection from unfair dismissal and minimum guaranteed hours. And we found, had these 2 measures been in place, the number of people in severely insecure work in 2023 would have fallen by around 1.2 million workers. However, this shouldn't be shouldn't spook employers too much, because as this graph shows, even after the implementation of the ERA, the extent of UK labour law will still be far smaller than that of comparable nations. So how is it actually all going to get rolled out? So the government is taking a phased approach to consultation and the implementation of the Act. Most of the Act is expected to come into force between 2026 and 2027, with consultations still ongoing. So this is leaving a fair bit of time for stakeholders to prepare for changes and to influence how individual measures will work in practice. So this graph gives a bit of an overview of how the measures are going to be rolled out over time. As you can see, the number of measures sort of increases over time, giving employers a bit more time to prepare for them. And I will be going into these measures in a bit more detail later in the presentation. So employers will need to start getting to grips with these reforms and preparing for these changes as they are phased in. Early preparation will help to ensure compliance, foster resilience, promote trust among workers, facilitate the smooth implementation of new rights, and reduce the risk of conflict, claims, penalties, and last-minute pressures. Sort of most pressingly for employers, there is a need to prepare for reforms that are going to be introduced in 2026, and that is going to happen in two waves. So the first wave of measures will be introduced on the 6th of April, and the second wave on the 1st of October. So I will now take a sort of closer look at key measures that employers will need to get ready for before they come into force in April. So first up, we have paternity leave and parental leave. So this will see that day one rights for paternity leave down from 26 weeks and ordinary parental leave down from 1 year introduced in April, as well as the ability to take paternity leave after shared parental leave. There'll also be changes to statutory sick pay, also known as SSP. So employees will receive SSP from day one of a sickness absence, removing the current 3-day waiting period. The lower earnings limit will also be abolished. So SSP will be paid at £123.25 per week, or 80% of normal weekly earnings, depending on whichever is lower. And this will see up to 1.3 million low-paid workers now being entitled to additional 1.3 million low-paid workers now being entitled to SSP. April will also see the launch of the Fair Work Agency. So this is a new body that will consolidate and strengthen the enforcement of existing employment rights, merging functions from agencies including HMRC and the GLAA to create a single point where workers and employers can turn for help. Not all the details have been finalised, and the FWA is expected to gain more powers over time. However, some duties that the FWA is expected to have will include the ability to investigate employers, undertake workplace inspections, the issuing of civil penalties for underpayment, and representing workers in legal proceedings. I think it's worth sort of thinking about the scale of the challenge the FWA is going to face. So currently, 900,000 UK workers each year have their holiday pay withheld, which amounts to around 2.1 billion, whilst nearly 20% of minimum wage workers are currently underpaid. Some further measures which maybe employers will need to prepare for, but perhaps not as much, that we brought in April include enhanced whistleblowing protections, collective redundancy, protective rewards, and simplified trade union recognition. So turning to the wave of measures that will be introduced in October, first off, there are new laws covering harassment and sexual harassment. So employers will be liable for harassment from third parties, e.g. sort of customers or clients, unless they have taken all reasonable steps to prevent it happening. And this will apply to all types of harassment. Employers will also need to take all reasonable steps to prevent sexual harassment, a change in the current law, which currently states reasonable steps as opposed to all reasonable steps. We will also see new rights for trade unions. So employers will be required to provide workers with a written statement of their right to join a union. Trade unions will gain the right to access workplaces both physically and through direct communication with workers. And we'll also see enhanced rights for trade union representatives to receive paid time off and access to facilities. There'll be new rules covering tipping. So employers will be required to consult with workers and trade union representatives about their written tips policy, and there'll be a requirement that that policy be reviewed at least once every 3 years. We will also see new rules on fire and rehire. So now dismissing someone, then rehiring them on worse terms and conditions will become an automatically unfair dismissal in the majority of cases. The government estimates that currently around 12,000 businesses engage in fire and rehire each year, affecting 125,000 workers annually. Other measures that will be brought in October will include regulations to establish the adult social care negotiating body, an extension of employment tribunal time limits, and additional protections for determinants for taking industrial action. It is also important for employers to start preparing for changes that will take place after 2026. And as Ben mentioned, the Work Foundation will be holding another event to cover these in a bit more depth. Currently, specific implementation dates for when these measures will be brought in 2027 have not been announced for a lot of the measures, and the specifics of how they will work in practice have yet to be determined. However, there are some measures employers should be thinking about now, most critically, the introduction of unfair dismissal rights. So this will see the qualifying period for unfair dismissal rights being reduced from 2 years to 6 months, and also the unfair dismissal compensation cap will be removed. So the government has confirmed that the reforms will be implemented in January 2027, which means that workers whose employment commences after the 1st of July this year will be covered by the reforms. Some other key measures to bear in mind for employers include rights for pregnant workers, reform of 0 hours contracts agency rules, the introduction of bereavement leave, and enhancement of flexible working rights. So how can employers start thinking about getting ready for the ERA? There are a number of steps that they can already start doing, such as reviewing existing policies on issues including family leave, tipping, and harassment, considering the implications of enhanced dismissal protections, undertaking an audit of employment contracts, considering if record-keeping systems need to be updated, providing training to HR managers to ensure compliance, as well as seeking out guidance from key stakeholders, including ACAS, CIPD, and trade union representatives. There is still a chance to influence how measures in the ERA will be implemented in practice, as consultations are still ongoing. So as you can see, some upcoming consultations which will be open to stakeholders include fire and rehire, regulation of umbrella companies, ending the exploitative use of 0 hours contracts, trade union measures including blacklisting, collective redundancy, flexible working, and the tightening of tipping laws. That's all from me. Thank you all for listening. I'll hand back over to Ben.
Thank you, George. And if I can just invite all of our panelists to turn their cameras on, that would be great. That was a very helpful presentation, George. Just to say, I think on the introduction of new regulations around sexual harassment, the slide said April 26. My understanding is that's October 26. So just so everyone's aware of that, but a super helpful overview, George. And I think what it sort of gives us a sense of is just the scale of change that is coming over the course of the next 12 and 24 months. Lots of opportunities to improve the quality and security of work across the country for millions of people, which is, of course, a very positive thing, but lots equally for employers to understand and to get their heads around and to be preparing for today. In order to try and get through some of these issues, then, I'm going to try and group some of the changes that George sort of took us through there to try and make sure that we get through as many of them as possible. And where I was planning to start was around some of these new rights for leave that George described. So things like statutory sick pay reforms, day one paternity leave and unpaid parental leave. And Claire, I was hoping to come to you first because I know at Abraham Moon, you've sort of taken a sort of progressive approach to introducing many of these kinds of enhancements, actually well before the Employment Rights Act has been introduced. So it would be great to get your perspective on these kinds of changes as an employer, why you've sort of taken some of those decisions that you have, and the kind of impact that you've observed for you as an organisation, but I guess also most importantly for your workforce.
Yeah. Well, hello everyone, and thanks for inviting me to this panel. Firstly, we introduced additional company sick pay to all our employees about 3 years ago, and that was driven by high turnover of staff, reduced engagement, poor morale, etc. So I'm sure many of us have been through that. We've got a group called Connect, which are a collective group, random people from around the business. What would they want? We asked a variety of people. And one of the things came was that security, really. People were coming in to work ill, visibly ill, presenteeism, and it was for the passion of the job, really, as well as the money side of things. So what could we do to enhance that? So we made a decision, or the previous management team made a decision to do day one sick pay. We enhanced to company sick pay, so all our employees get at least 2 weeks full pay, obviously following correct reporting procedures, etc. Paternity pay was the other thing I've asked to talk about. We only brought that in last August, September time, 2024. And again, day one not day one right, but increased pay. But we are changing that obviously very soon to day one right. And we've seen a massive uptake in that, which is great. We're a family business. So we want to encourage that family feel, and what's better way to do it than paying people, when they've got children. And we've had so much engagement from that. Our retention is better. So why wouldn't you do it, really?
I mean, that's fantastic to hear that positive experience, Claire. But before I bring some other colleagues on the call in, I suppose some employers who are listening in today might actually be a bit anxious about the changes and might imagine a world in which, they're going to see more colleagues claiming sick pay than they did before, or it's going to result in a net cost to the business. Did you have to sort of guide colleagues through some of those challenges as well? And now that you're a little while in on the sick pay changes, what have you seen in terms of sort of utilisation of those new rights?
Yeah, I mean, to be honest, we did see a little spike in sickness absence. But if you think from a cost perspective, with the new regulations, it's only going to be at the most an additional 3 days' pay for whatever sick pay they were taking. So from that, we've just improved our absence management processes, line management training to try and combat that. And we did see a dip from it went up to about, which is not high, 3.2% the previous year, and then it's dropped to about 2.9%. So we're gradually seeing it come back down again. But we want people to be off work when they're not well, because otherwise we've seen that when it's just spread throughout a department, and the impact on that has been much more severe than one person taking a week off. So I think if you've got that correct measures in place to look at, one, cost is really important, but also the impact on the business from a department perspective, but also the wider business. And I think it's just better planning needed, and those comms with the staff as well, explaining what impact it has when they're off, and return to work interviews are just key again.
Yeah, fantastic. Thanks so much for that, Claire. I may come back to you for more reflections on it. But Laura, I also wanted to bring you into this, and maybe just building on some of the things Claire's been describing there. Are there things which you think employers need to be mindful of now ahead of the introduction of some of these new leave rights? And I mean, Claire mentioned in particular there, I think supporting line managers to sort of be in a position where they can, confidently engage with staff around some of this. Are there other things that you think employers need to be thinking about ahead of time?
Yes, I can give you a little snapshot of what I would say are good things to take into account. So I'm sure a lot of people who are listening to this event will be aware of the government's roadmap, which I know has been updated a little bit prior to the Act coming into effect. But I think that's a really good tool just to use to kind of map out what changes are going to be taking effect broadly when, so you can make a plan. Create a compliance plan, so sort of map the changes, work out who's going to be responsible for what. Consider what contracts and policies that you need to update. I know that George mentioned briefly, are there any kind of systems and processes that you need to look at, like HR payroll systems, recruitment and retention, sort of broadly? You'll need to have a bit more about that. So I'm sure, there'll be really good employers listening to this call who are very careful about those things, but we may come on to it a little bit later, but with unfair dismissal changes coming into effect. So, the 6 month lead into that, right? I think employers might be well placed just to be really mindful about the decisions that they're making on performance reviews and tackling issues early. Training your managers so that they know exactly what's going to happen when, and just sort of building a timeline. So I hope that's helpful.
Yeah, it absolutely is Laura. And Samson, bring you in now and just get a sense from you, particularly on these leave rights, how Unison members are feeling about those changes. I know you've been part, as the Work Foundation was, the sort of campaign around safe sick pay and strengthening sick pay rights in particular. Yeah, it'd be great to get a sense of how your members are sort of feeling about these forthcoming changes and how impactful you think they might be.
Yes, as Unison, we're a public service union, and thank you, for the invitation. We have 1.2 million working members, so we're very large, 70% women. So you can imagine, yes, for both across the board, actually, day one paternity leave, the extension of parental leave will be extremely popular. But on statutory sick pay extension, there's a lot of workers who deliver public services, who work in the voluntary sector, private contractors and social care, who don't have access to sick pay from day one. And they are in very front-facing jobs, of sometimes with critical care, social care and patient care issues around hospitals and social care facilities, children's homes, and a range of other issues where it is actually, as colleagues just said, it is critical and best for the organisation. If they are sick, then they should be off work. And I know SSP as a weekly amount is not a king's ransom, but it is very exciting, I think, for our members who work for large contractors. And I think some of that was the colleagues will be able to share experiences about the pandemic, about key workers. Sometimes those workers on the front line who were at the front of the COVID pandemic were those without actual access to sick pay. And I think this move, though we'd like to see the rate increase, obviously, the weekly rate, this is a big step forward, the sick pay move in April. Yeah. So, okay.
Brilliant. Thanks, Samson. And Alice, I'd be keen to bring you in on this as well, because you've published for the Work Foundation around the sort of unequal access that many workers have, as Samson was just sort of touching upon a little bit there as well, to a whole host of leave policies. How sort of confident should we be that the changes in the Employment Rights Act are going to start to address some of that? And what more can employers be doing to make sure that it does?
Yeah, so our research has shown that low paid workers on the whole take less leave across a whole range of leave types. So parental leave, sick leave, holiday. And this is often because some of those rights to leave aren't paid. So there is no statutory obligation for those rights to be paid in some cases. So these changes improve that to some extent for some of those types of leave. So, for example, the first 3 days of sickness leave, now people will have a right to statutory sick pay. So that is really important, particularly for those low-income workers that I mentioned. But with some of the other changes happening, whilst they are improvements, they don't actually come with a duty for that leave to be paid. So with the parental leave and the paternity leave from day one that's being introduced, that is really positive. So it means people who are new to a job, if they become a parent, a father, soon after taking on that job, they can take leave so that they can spend time with their child. That is obviously positive. However, the right to paid for that time to be paid is not changing. So there will still be a kind of period of unpaid leave that person would have to endure. So we think this will still have a kind of unequal effect. People on low incomes won't necessarily be able to take that up, but we think it's a step in the right direction for sure. And it's worth saying as well, the government have committed to a review of parental leave policies and pay across the board. So hopefully more changes are coming.
Yeah, that's right. That review is ongoing, isn't it? That's really helpful, Alice. And I suppose, Claire, to sort of come back to you and your experience as an employer, I suppose what situation Alice has just outlined there does provide an opportunity for employers to take the lead actually and go beyond the sort of statutory minimums. It'd be great to get a sense as we sort of tie off this section of the session this afternoon from you, what you have in mind going forward as an employer, whether you've sort of seen increased staff engagement from some of the changes that you've introduced so far, and whether you're looking to kind of further strengthen that employee offer in the future.
Yeah, well, we've done quite a lot already. I think we've increased maternity pay and paternity pay, as I said earlier, and everybody's entitled to at least 2 weeks company sick pay. And we do extend that under certain circumstances. We just want to take that worry away from people if they're ill, or if they're ill, they need to concentrate on getting better. And also if they've got a new baby, they want to concentrate on that and enjoying that moment. So anything we can do to to help them, we will. Obviously, there's a cost. We've got to be cost sensitive and cost cautious for that. But I think going forward, the next thing we will probably look at is things around future planning for pensions and trying to help some of that. So I know it's sort of the other side of the family structure, but how can we just look after them throughout the whole of their employment life cycle and their life cycle, hopefully while they're still here at Moon. Does that answer your question?
Yeah, no, that's brilliant. Thanks, thanks very much, Claire. So I'm going to move us on now to spend a little bit of time discussing some of the changes that will hopefully strengthen collective protections for employees at work. I am seeing quite a few questions pop up in the Q&A tab now, which is brilliant. Thank you so much for doing that. And some of them are absolutely relevant to this next section of the conversation, so we'll get into them as we go. But Samson, to sort of come to you first and just get your sense of the likely impact of changes introduced in the Act to particularly strengthen union access rights. It's clearly been one of the more political elements of the Act in terms of how it's been discussed within Parliament and within some of the newspapers. But do you think it can usher in a sort of stronger sense of worker voice within organisations and ultimately lead to better decision making?
Thanks, Ben. Yes, I mean, from the collective side of the bill, we're very obviously excited. Won't surprise you from the union movement about access rights coming in October later this year. Statutory linked to possibly easier statutory recognition procedures. We have many thousands of members in small employers, in fragmented delivery of public services, social care, schools, and a range of other areas where we struggle to get access and represent members and to get reps elected to sort of work with HR departments as well. So yeah, we see it as definitely an opening. I don't think it's going to be a big bang for employers out there. We're going to, from a Unison Public Services side, I could see us concentrating particularly in social care, where there's a new negotiating body, where we want to build a mandate of members actually, so we can speak with authority in that negotiating body in adult social care in England. There'll be equivalent bodies, Wales and Scotland, possibly going into children's social care as well. But yes, we could see social care as the sector we really concentrate on trying to speak to social care workers in their lunch breaks and outside and in workplaces outside regular working time, but in as agreed with employers. And that could be a real opening for us to engage in conversations in workplaces. And hopefully the workers would want to join trade unions after those conversations. But it's and we hope we get a chance to make that case to them actually, because there are we've got thousands of workers in fragmented sort of public services. So yeah, we see the things working together, the access and the recognition. Schools and social care for us as a public service union will probably be the two areas where we'd concentrate on trying to speak to workers, in cooperation with employers.
And again, Samson, I suppose similar in a sense to the follow-up I asked Claire, particularly given some of the sort of wider debate around these changes in particular, I suppose there may be a number of people on the call today, employers who are concerned about the implications of some of these changes and what it might mean for how they run their organisations. Just taking a sort of step back, could you maybe just sort of describe why, from your perspective, why from Unison's perspective, actually, you know, the sort of greater access to being part of a union actually can bring benefits within the sort of culture of an organisation and within the sort of decision-making frameworks of organisations?
Absolutely. I mean, we obviously believe that recognising trade unions is good for businesses and organisations. It helps with collective decision-making, gives workers collective voice as well. It's efficient as well, and hopefully leads to better terms and conditions and engagement as well. So yes, we think it would be a win-win you'd be surprised if I'd said otherwise, to recognise unions in workplaces. But it may be after sort of the last 30 or 40 years of employment law, it may be, yes, new to a lot of employers as well, talking with trade unionists as well. But I mean, I assure you that, you know, the front line of the union movement is elected local reps. There will be, first and foremost, your organisation's employees. They'll be elected by their fellow workers. We'd ask for a certain amount of facility time to be granted to them. You'd be talking to people who knew your organisation, knew your culture, It wouldn't be, there's very few of us actually. It might, if you read the Daily Mail, you'd think there's an army of full-time officials out there marauding around. The front line of trade unionism is elected local reps who will be your employees, and they will be the ones, probably often in the first instance, maybe talking to your HR department or unit or whatever. And so, they've been brought up in your culture, in your organisation, as well, so they understand the business organisation of a public service. So, but that's what we'd hope to see happen. Yeah. So.
Brilliant, thanks, Samson. There's a particular question in the Q&A around fire and rehire that I do want to come back to, and Laura and Samson, I may come to you on that if I can. But Claire, just coming to you next from the sort of, again, employer perspective, and of course there'll be a whole diverse range of employer perspectives on this depending on the size of organisation and sector that one is in, but just sort of sticking within this sort of strengthened union access and sort of reforms part of the agenda. What's your sort of take on this as an employer, and do you anticipate changes within your organisation as a result?
Yeah, I must admit we are a little nervous, shall I say. We've got obviously some members of staff are members of unions, but we only tend to see them when we have a fallout. So it's working with them differently and getting used to that. And we've also got our employee forum, which works really well. So we sort of raise issues there, they raise issues to us, we have a discussion and we generally sort it out. So and we're a small business as well, so I know it's different with larger businesses, but I'd be interested to see, what benefit they can give us as a business, but also the members. And we're from Yorkshire, and they're very well how they spend the money. So it depends on how much it costs to join a union, how they want to spend that money. But I think because we work quite well together now with the employee forum, if we recognise a trade union, I'd hope that the biggest part of their effort would be working with the HR team to begin with, as well as the members, and build that trust and rapport within that group, and then we can all work together. Other than that, I don't see it working, but that's just my opinion in our business.
Brilliant. Thanks for that, Claire. I'm going to bring in now Samson and Laura, perhaps. So on the fire and hire restrictions, we've got a particular question from John Kirkham, which is, do the fire and rehire restrictions mean we can no longer dismiss with an offer of re-engagement on different terms and conditions, which is essential to impose changes to contracts if persuasion and consultation fails? And or are we faced with employees who refuse reasonable changes necessary for the business? Laura, I've seen you've unmuted, so I'll come to you first on that, if that's okay.
That's fine. If I maybe give a snapshot of where we are now and what's going to happen going forward, I think I'll probably answer
super helpful.
Quite well. So just first of all, to briefly outline, in case people don't know what fire and rehire means, it's when an employer dismisses employees and then immediately offers to re-engage them on new, often less favourable terms and conditions. And it's technically lawful today, but it's increasingly high risk. And it's going to be heavily restricted under the Employment Rights Act from October 2026. So it's currently lawful, but as I said, high risk. And there is in place a code of practice from 2024, which was introduced and means that if it's not followed, so if you don't consult with your employees and inform them properly, they can have their compensation if they make a successful claim in the employment tribunal increased by up to 25%. And there was a lot of, I think, public outrage, particularly following the P&O ferries scandal, when people were dismissed and then attempts made to replace them with cheaper labour. So I think that's probably partly why this came about. Under the new rules, which are going to come into effect in October this year, if you dismiss staff to impose changes on key terms, which would be pay, hours, pensions, shifts, time off rights, other protected terms, that will be automatically unfair if you dismiss the employee because they've refused those changes. And then those restrictions, the new ones, will also cover fire and replace situations. So where you're replacing employees with contractors, agency workers, other non-employees, those dismissals will also be automatically unfair unless the business is facing a genuine near insolvency situation. There's no other reasonable alternative. So there are some exceptions that may apply. And then if you've got contractual changes outside those protected categories, they won't be automatically unfair, but tribunals will still assess fairness based on consultation, reasonableness, and what was actually offered to the employees. The the code of practice that I briefly mentioned will continue to apply and is expected to be updated, but that's still pending at the moment. So it's high risk at the moment. So you need to make sure that you do it properly and follow the code. And then going forwards, if you feel it's high risk, it's probably better to do it now rather than later. Not that I am advocating for making unfair changes that will affect employees badly. But yeah, you need to be careful, essentially.
So I suppose given what you've just described there, Laura, to try and directly answer John's question, essentially the answer is no, you will not be able to do that in the future, other than in very, very exceptional circumstances.
I think other than in exceptional circumstances, if you're talking about the sort of key terms that I referred to, if it's outside of that, then I think it would still be easier, but you'd still want to be careful to do it in a way that is lawful. And then if it might be that you trigger protective awards as well, if you've got 20 plus people that you're dismissing and then re-engaging on new terms, which would be under the collective redundancy legislation, and protective awards are due to be doubled as of April this year under the Employment Rights Act. So there's that you're basically being told from all angles that this is not a thing to be encouraged, and if you do it, you need to be very careful about being fair to your employees. I would say.
Brilliant, thank you, Laura. I do want to just bring Alice in and sort of maybe round off this part of the conversation, but obviously if there are other points that colleagues want to bring in, please do. Alice, I want to sort of maybe take you back to what Claire was describing, and Samson to a degree, actually, maybe from slightly different perspectives, but which I think was really a conversation around the sort of culture within organisations and how we can sort of harness, actually, as an opportunity, increased access to unionisation to build a better dialogue between employers and employees, and ultimately that, whether that's the sort of the prize here that's on offer. And of course, please do come in on any of the other bits of the conversation. So
yeah, I mean, I think it's worth reminding ourselves how long this bill or this act has taken to get over the line. And it's been a decade in the making, really, if you think of kind of earlier iterations or discussions of kind of similar proposals. And that really shows us how slow employment law can be, or any law really, to change, because it has to take into account, so many different factors. And I think what is really important and interesting about the improvements to trade union access and some kind of improvements to the ability of workers to be able to sort of collectivise their own voice in work. I think the reason they're important is because, in a sense, it's devolving some of that responsibility down to workplaces themselves. It's allowing employers and workers to come together and think about, what are the problems occurring? How can they be fixed? And when it's done well, that can be very efficient, as I think Samson alluded to there. It means that issues are being raised, together at once, and employers can really think about how to resolve that and change things, rather than having to deal with every single individual case at a time. And generally, union representatives are volunteers, they're colleagues, they're people that you work with. And so this can be a really great way to deal with sensitive issues like sickness absence and maybe other problems occurring in the workplace that would really benefit from having more kind of mutual support and mutual aid and kind of workforce representation. So yeah, I think this is a really positive change. I don't think we're going to see huge changes overnight, because I think, as Samson alluded to, people involved in unions are already quite stretched and busy. So I don't think we're suddenly going to see lots more unions in lots of workplaces that didn't have them. I think particularly with small and medium-sized businesses, I think the challenges to form unions will still be there in spite of these changes. So I would imagine, Claire, it sounds like, you're already a good employer and you already have forums for employees to come together. So I wouldn't imagine these changes will make any significant or radical changes to the way you already engage with your workforce.
Brilliant. Thanks, Alice, for that. Really, really helpful. I want to, if it's okay with everybody, move us into the sort of next bundle of changes to make sure we sort of cover them off as well, because we've had a couple of questions in this sort of area too, which is around discrimination and rights, and I suppose in particular beginning around the sort of changes that are being introduced around the duty on employers to prevent sexual harassment. And Laura, I thought I might come to you first, just in terms of how significant the changes that are being introduced, because I know some of the language is sort of being updated, and what perhaps we know and what we maybe don't know just yet in terms of what that might mean for employers. And we've had a specific question from Alexandra in the Q&A tab, which is around what will the process of enforcing third-party liability harassment look like, which maybe in a sort of slightly different area, but I'm keen to start picking up some of the audience Q&A questions as well. So if you are able to sort of address some of that as well, that'd be great.
Well, I will try and address it in the round. I don't know if we know the detail about that latter question, but I'll certainly pick it up. So at the moment, as of the 20th of October 2024, employers have been under a duty to take reasonable steps to prevent sexual harassment in the workplace. And if they don't do that, there can be, again, if there's a successful claim, an uplift of up to 25% of an award in the Employment Tribunal on that. And the Equality and Human Rights Commission can potentially investigate and take enforcement action. There is guidance from the Equality and Human Rights Commission that was published in September 2024 about what reasonable steps means. And I think there was a DBT fact sheet with information on that, on what reasonable steps might be, as well as all reasonable steps, which has been updated recently. So from October 2026, it's going to be more challenging for employers. And again, I'm not saying that's necessarily a bad thing, but employers will need to comply with the higher duty, which is to take all reasonable steps rather than reasonable steps to prevent sexual harassment taking place in the workplace. And there's going to be a new duty again from October 2026 to prevent third-party harassment. And that's going to be particularly important for employers that have public-facing employees or employees that just interact with other people in the workplace. So it could be in, I don't know, leisure, tourism, social care, all sorts of different sectors. And I think the updated DBT fact sheet has said that what will constitute all reasonable steps will depend on the specific circumstances of the employer, such as their size, sector, working environment, resources, and relevant facts. So you've really got to think as an employer, how is this going to affect me as an employer? What are the kind of pinch points there for my employees? The detail on the regulations and what will actually constitute all reasonable steps, I believe, is going to come into effect sometime in 2027 to 2028, I want to say. So it doesn't come into effect at the same time as this duty. So I think the duty is going to be fleshed out sort of in the future. But there are things that employers can do now, I think, and should be doing in any event. So having a look at their policies and procedures and making sure that they're visible to staff, ensure that there are things like sexual harassment, dignity at work, and grievance policies are up to date, provide meaningful training to staff and managers. And that's really important in terms of making sure that you comply with your obligation to take all reasonable steps. In fact, I'd say it's crucial. Make sure that you're acting consistently and quickly if those types of allegations come to your attention. Train your line managers. Make sure that you are dealing with everybody fairly. So not just the person who might be raising the allegations, but the person who the allegations have been raised against as well. Assessing where your high risk areas might be. So things like maybe lone working, late night shifts, customer facing roles, offsite events, and just taking a sort of a general zero tolerance approach to things.
Fantastic. Well, that's really helpful. And just in terms of Alexandra's question itself, and this may be too early to answer, but I think she's asking, what will the process be? Am I correct in understanding from your outline there that some of that we're not quite sure, but in a sense, the process may remain the same, but the test is being strengthened?
That's right. Exactly right. Yes. So it will be all reasonable steps to prevent third-party harassment. So that would be thinking about customers, clients, contractors. How are you going to deal with issues that come to your attention? Some employers have had in the past and may have sort of going forwards signage up or messaging that comes through. If you call a call center or something like that, you might hear something to say, treat our staff in an appropriate manner. Third-party harassment or protection against it or liability for employers used to be something that was in place, but it then fell away. So it's coming back again. But I think it is an important step for employers to take, and something, even though it's not explicit currently, should be something that employers are doing anyway in terms of a duty of care to their staff.
Brilliant. Thanks, Laura. Claire, I want to come to you to get your sense as a sort of an employer. And we have had a question, particularly around small businesses being disproportionately affected. I know you're more of a medium-sized business, but it nevertheless be good to get your sense of that issue area or that perspective on this in particular. But before I do that, Samson, just to come to you in terms, because I know you've described some of the the members that you represent. No doubt we'll be in some of those roles that perhaps this third party harassment issue is particularly relevant for. So if you could just get your reflections on this part of the Act and what you're doing as a union to perhaps help prepare your members for it.
Yes, the front-facing, customer service-facing side of public services, as well on, as you said, the extension around third parties or contractors and a range of things. We're very pleased with the tightening up around this area. We're hoping, though, as well, that they are mentioned that in the Act there is a provision for unions to locally elect equality reps as well, who might take up issues around pay gaps, sexual harassment, and a range of different equality-related issues. So we're hoping that we can provide, a lot more local support to both prevent sexual harassment or risks as well at source, so that they don't become, cases and tribunal cases as well. So yes, we take it very seriously, and broader, not just sexual harassment. A lot of front-facing workers are receiving a lot more abuse at work generally, actually. I mean, from water workers, I'm afraid the public, the state, and customers, clients as well. So there's from a range of just broader than sexual harassment as well. So we've got it shooting up our agenda as well, but broader issues of respect at work actually as well. And preventing sexual harassment, vitally important that we see a growth, hopefully for us, of local equality reps who can try and nip this in the bud as well, in addition to the local reps as well. So thanks.
Brilliant. Thanks, Samson. Claire, if I can just bring you in on this particular point from an employer perspective.
Yeah, so as Laura said, we have reviewed our policies and procedures as well. We've got a dignity at work policy, and we've got a handbook. We think we've got everything in place. But I think as everybody's touched on, it's about getting those out to people and making people feel comfortable to raise issues. So we're doing lots of line manager training. We're just planning to do some sort of dignity at work training for the rest of the workforce as well, so they've got an awareness. But it's all around that psychological safety as well, to make people feel comfortable to raise any issues. And we're also training our mental health first aiders, because sometimes issues get raised with them on the back of something else. So what they should do and how they should deal with it. But I think it is all around that training. And we've got a diverse workforce. It's quite a traditional business, textile manufacturing. So some things that were okay, I don't know, 30 years ago are not okay anymore. And it's about explaining and discussing that with the sort of original colleagues in the business and the older end, really, just to say, look, things are different. So we do training on that, but most of it's about good communication and listening.
And just while we have you on this, just to that particular issue around smaller businesses, from your sort of professional experience, how, if you were a smaller organisation, perhaps more capacity constrained, are there sorts of particular things that you would advise those smaller organisations to be prioritising in amongst everything?
I think reach out with and see if you've any other businesses you can utilise. We work with Leeds Mind as well. They're really good, and we've got some good connections there. I'm on the steering committee there, so we have people in different businesses that can help, and sometimes they'll come in and help us and we might go help them. So I think it's about partnering with other smaller businesses sometimes, and local services like NHS have been really helpful for us. Stella Trust, they've been helpful. Any of us can help. But again, I think we're quite lucky that because we're a smaller business, we know most of the employees as well, but we know what their story is, so we can preempt some issues, and we can also train in-house. So, I can train, the HR team are quite good at that. So we can deliver some of that ourselves. So in that sense, we're quite lucky that we're not needing big bucks to sort it out.
That's brilliant. Thanks, Claire. I've seen there's a question around the sort of potential costs per employee for the additional sick pay and leave. I'm aware of a few studies that have been done in this space, which, I mean, obviously they're going to be generalizing in terms of the overall impact. But we can potentially include some links to that in the sort of pack that you send out post event. But obviously, Claire earlier in the event has described some of the upside from this. So it's trying to kind of take a rounded view, I think, in terms of the sort of costs and benefits to businesses of putting those sorts of measures in place. As part of this section of the conversation, I do want to move us now into the sort of preparing for the unfair dismissal changes as well. And Laura, I'm going to come to you in a second to just sort of give us a bit of a deep dive in terms of what practically this might mean. But Alice, I thought I might come to you first, if that's okay. To just sort of outline why this is important in terms of, driving up security in the UK labour market.
Yeah, certainly. And it relates to the conversation we were just having as well, actually, with regards to discrimination. So just to talk briefly on that, I think being at risk of harassment and discrimination in work compounds insecurity. So a number of the measures that are being brought in to make work more secure for people are also important overlaps with some of these changes around harassment and discrimination. We know that women are overrepresented in some of the most insecure forms of jobs, and particularly young women. So I think some of these changes are really crucial for that cohort. With regards to the unfair dismissal changes, I think these are a major plank really of the reforms that are happening. I think it's where we're going to see a lot of the improvements to security at work for people who are new to a job and haven't yet had the opportunity to accrue rights and protections from dismissal. So we've made some estimations about the numbers of workers that will be brought into a more secure position as a result of this, and it's significant. We're talking millions of people potentially, depending on how things are delivered. So we do think this is a really crucial part of the change. We know there's been a lot of debate and deliberation about where to set the bar, and I think we're quite pleased that it's landed in a place that is easy, hopefully, to communicate and isn't bringing in a whole new layer of kind of timings and dates. But I'd be interested to hear from Claire, Samson and Laura on that issue, actually.
Brilliant. Thanks, Alice. And you've done my job for me in terms of a segue. Laura, I'll come to you first, if that's okay, just to sort of remind us, because George's presentation was a little while ago now, just in terms of the specific changes that are coming in, and then I'll come to Claire and Samson.
Cool. So just a brief overview then. So most of the changes that we know about are the ones that we're focusing on today are largely coming into effect April and October 2026. This particular change is due to come into effect in 2027, and we've had more certainty now on when it will actually take effect, which is as soon as possible, which is the 1st of January 2027. And it came about, there was the flagship policy of the Labour government that they wanted day one unfair dismissal rights, and there was a big sort of people called it ping pong, didn't they, between the House of Parliament, the Commons and the House of Lords, a disagreement there, and they reached stalemate, and in the end there was a compromise on it in effect. So the current qualifying period for ordinary unfair dismissal rights of 2 years currently, that's excluding some automatically unfair dismissal rights which apply from day one already. It's been reduced to 6 months as a qualifying period, and it's historically gone up and down from 1 year to 2 years. And I think there was a short period historically, probably even before I was an employment lawyer, of 6 months. So we've gone back to that. And the way it's been changed, as I understand it, is through statutory law. So it's going to be harder to change going forward. So there won't be that same kind of flexibility in terms of, the political regime changes and then it goes up again. Let's say if a right-wing government comes into more employer-friendly, shall we say, comes into power and up to 2 years again. So I think we're probably going to be at 6 months without some substantial change in the law. So that means these new rights will take effect from the 1st of January 2027, so that if you have people who are starting employment perhaps in July, August 2026, they may well start accruing unfair dismissal rights from that point, and then that will come into effect as of the 1st of January 2027. There's another strand to this as well, which is the compensation cap is being removed. So currently, for unfair dismissal claims, generally there would be a compensatory award and a basic award. Basic award is unaffected. That is calculated in the same way that you would calculate a statutory redundancy award. But the compensatory award is the lower of, I think it's currently £118,233 or 52 weeks pay. So that cap is being removed. Again, I believe it's with effect from the 1st of January 2027. When we were talking about having day one rights, there was a proposal to have an initial lighter touch process in dismissing employees that employers would have to follow in order to be legally compliant, but that isn't going to apply anymore. So it's just whatever you would need to do now in terms of a fair process and finding a fair reason for dismissal. So I know that Alice was talking about this right affecting a wider group of people, and I've seen government statistics where they're estimating that a further 6.3 million employees will be protected against unfair dismissal. And I think also the thinking is that it will benefit high earning employees, so that's a relatively small group of people in terms of the cap being removed, but also those that have limited re-employment opportunities as well, so that there won't be that same limit that applies at the moment. So hopefully that will give you an overview.
Brilliant. No, that's a really helpful summary. Thank you for that, Laura. Claire, just to sort of come to you in terms of then, as HR director, what then are you thinking about with January the 1st in mind? Does this sort of reshape your recruitment plans this year, and what changes might you be making to sort of respond to the sort of forthcoming change in the law?
It doesn't change our recruitment plans. We've already recently, partly because this coming into force, we have changed our probationary periods to 6 months to match the unfair dismissal timeline, and trying to work towards that now. So sorry, but it's back to line managers. I'm sorry to dump on this on you line managers, but for us, it's back to that line manager training. I'm sure we've all worked for organisations in the past where you've had that employee that's not very good, and the manager's gone, they've always been like that for years. Well, that's not acceptable anymore. So again, it's line manager training, making people aware, and I think tighten up your recruitment practices. I know, we've changed ours certainly. We just do it, we're more thorough. So I think putting that time into recruitment is definitely worth it to have the best chance of getting that best employee you can for whatever vacancy it is, and then being strict with your probation. It's not just a tick box. It's not just a form that HR want to file in a drawer. It's not about that anymore. It's to use it properly. So training line managers how to carry out those probation reviews and making them meaningful from both parties. I think that just helps going forward, and hopefully will avoid any trips to tribunal.
Yeah, no, absolutely. And I mean, your point there around line managers, we hear this a lot across lots of different strands of our research in terms of the critical role that a good line manager can play, particularly for people who are in more insecure work settings, or who, for example, have got a health issue or what have you. I do worry a little bit about the amount of additional expectation and responsibility line managers are going to face over the coming period. And we're not terribly brilliant. There might be some exceptions company to company, but we're not terribly brilliant in the country at supporting them. So I think it is a sort of something for policymakers to be thinking about, as well as employers themselves. Samson, I'll come to you for any reflections on unfair dismissal, and then for the final sort of 5-10 minutes, we're going to move into the Fair Work Agency analysis. I'll come to you to start somewhere.
Yeah, thanks, Ben. Yes, obviously, yes, it's a very significant new right for employees coming down from 2 years to 6 months. And as Laura said, I think there was a period in the 1970s briefly when it was 6 months as well, but it has generally been between 1 year and 2 years. But yes, it is 6 months. It is in primary legislation. It won't be at the control of a ministerial order to change it in future. It would require primary legislation, an act to change it as well. And we think that's significant too. I think we think of this broader as well, and it was mentioned in your presentation. The thing we're very pleased about as well is that the tribunal period goes for many claims goes from 3 months to 6 months limit and because we know, as you said, local reps, as people said, in the first stages of helping employees, employee can mull on a problem, an issue, an incident for some time, speak to family and friends, maybe then speak to the local union rep, who then speaks to HR, who might then speak to a regional official, who then has to work out whether to bring in a lawyer to assess the situation or not, collect evidence. That 3-month limit can be very stressful for both the employee and the union rep and the people around them as well. So we see that combination with the extension for a lot of the claim areas from 3 to 6 months as particularly important to helping local reps, who are not myself, are the backbone of the union as well, and that's what all power to their elbow, and that combination, I think, hopefully together means that, as Claire said, yes, with good line management, good HR and good relations and working with unions where necessary, you can nip these things in the bud and avoid tribunal or negotiate or use internal grievance or collective grievance procedures as well, or whatever as well. I know I've gone broader than unfair dismissal there as well, because if it's got to dismissal, it's serious already. But you're hoping to intervene before that, as ever, So and as ever, not and negotiate, not go to tribunal with the union, So
absolutely, and as we come into the sort of Fair Work Agency and enforcement side of things, I actually think what you've just been reflecting on there sets us up quite nicely, because Alice, I'll come to you on this. As George mentioned at the sort of the head of the meeting, we're also expecting government to strengthen enforcement of these new rights. We're going to have a new agency. It'd be great just to get your sense of how you see that sort of playing out. We've also had a question, which it would be good to touch on if you can, and it speaks to some of Samson's comments there around the pre-existing backlog for employment tribunals, and whether we're sort of worried a little bit about that maybe getting even worse. So if you are able to find your way there, that would be great.
Great. So it's really important to talk about enforcement with all of this, because really it's the enabling condition for a lot of what we're talking about today. It's the backbone really of the Employment Rights Act. And that's because rights on paper only really mean something if people can actually enforce them. And we know that up to now, the enforcement landscape in the UK has been disparate, it's been disconnected, it's been underfunded. Most people don't know where to turn if they have a problem at work. There are inspectors doing great work, but there aren't enough of them, and they are spread out over a number of different government agencies with obscure names, and nobody really understands what they do. So the change is that we're going to have a new agency called the Fair Work Agency from April. This will bring together a number of those different enforcement functions. So HMRC's National Minimum Wage Team, the Gangmasters and Labour Abuse Authority, and the Employment Agency Standards Inspectorate will be coming together under one body. It's going to have an expanded scope. So in addition to enforcing the minimum wage, the FWA is also going to be enforcing statutory sick pay, holiday pay. It's going to be looking at umbrella company compliance, so looking at some of these kind of recruitment agency models and sort of non-standard forms of work that can introduce complexities and often labour abuses into the system. And they'll also be enforcing certain aspects of the Modern Slavery Act as well. One of the most exciting changes, I think, is that the inspectors are going to have stronger powers to investigate and audit and take action. So they're going to try to move from a complaints-driven model to a more proactive enforcement approach. But that is challenging because they're not really getting necessarily enough resources to be doing that per se. And I think that's why what's going to be really important is that enforcement is seen as a kind of ecology of organisations. So not just the Fair Work Agency. I mean, I think it's important that we have this new shop front now, so to speak, for enforcement, but we need to remember that they don't sit in isolation. We have trade unions, as we've talked at length about already. We have ACAS, we have the Health and Safety Executive, and to some extent we have employees associations, professional bodies, company owners and investors, and all of these actors have a role to play in enforcement. So I think a key kind of challenge for the Fair Work Agency and a key kind of measure of its success will be, can it bring together that sort of ecology of enforcement into a useful whole so that it can really use the resources that it has very strategically. And I think it will need to use data. It will need to be looking out on the front foot, looking at data and trying to understand where these labour abuses, these future risks might be occurring. So yeah, definitely one to watch and a really important part of the changes. And you had a question, let me remember, which was on the tribunals backlog. Yeah, and I think, you know what, I think that is a fair assessment and it is probably something that could occur in the short term. I think we're heading in that direction anyway, that, you know, the tribunal system already has a backlog. When a system has a backlog, that backlog tends to grow until, you know, something is radically changed. And these new rights, I think, at least in the interim, are likely to produce more cases and claims. I think trade union representatives are also going to be under pressure. ACAS is going to be under pressure because they deal with a lot of these cases before they get to tribunals, and they're doing fantastic work to do that kind of preliminary bit of negotiation and resolution. So I think a really smart place to invest resource would be in a body like ACAS, so that it can do more of this kind of pre-tribunal work, and also to continue to support trade unions to be doing that work too.
Brilliant. Thanks, Alison. And just very briefly, given what you've described there, is your sense that we may see the Fair Work Agency in that sort of revised infrastructure perhaps focusing in on particular sectors or particular areas, data-driven perhaps, but where the sort of problems within the labour market are most acute?
Yeah.
And you have a sense of how that might work?
Yeah, I mean, there are already sectors, problem sectors, shall we say, that some of those agencies that are being combined are already looking at. So food supply chain, agriculture, fruit picking being examples, but also social care recently has become a real hotspot for labour abuse with regards to caused largely by the changes to kind of visa rules for social care workers. And so I think those sectors will remain a focus, but I have seen that there's going to be a kind of strategic look into the gig economy as well, and the kind of proliferation of non-standard forms of work into other sectors that may have not, you know, been using those types of work previously. So retail, hospitality, construction, I know, is an area of focus. And this is where it can get a bit tricky as well, because something that hasn't come up yet on the call is the fact that these changes are happening to employees, not to self-employed workers. But as we know, there is some ambiguity over employment status in the UK, whereby some people are engaged as either workers or self-employed contractors, and so won't be getting some of these new rights. I think what's going to be tricky for the Fair Work Agency is working out how to direct its focus to benefit as many workers as possible within those constraints.
Brilliant, thank you, Liz. Samson, I'll come to you just briefly for any reflections you have on the sort of enforcement regime, and I mean, you'd already touched upon it a little bit in terms of the pressure that union reps and sort of the backlog within the claim system might be. Any other reflections you've got? And then, Claire, if there is anything else you want to come in on, please do sort of gesticulate wildly, and I'll see you. Same with Laura. Otherwise, I'll start wrapping this up after we've heard from Samson.
Yes, we want the Fair Work Agency to be a success. Actually, there is a very real tribunal backlog at the moment, actually, about the listing of cases, and we have joined the dispute resolution task force convened by the DBT to try and offer solutions to that too. But we really want, the Fair Work Agency, particularly small value claims, which are big amounts for the workers, I hasten to add, but on holiday pay and sick pay. And though it's not in the remit, you know, there could be small compensation claims, but important for the worker for late notice cancellations under the 0 hours contracts rights. That seems entirely appropriate for sort of a Fair Work Agency to get involved with, if it's a sort of, I'm guessing, you know, a £30 to £50 payment for a short notice cancellation where the worker might have had train fares or something literally to be cancelled on the door of work, you know, as a 0 hours contract worker. So it's or wherever the payment's set. So you could see for small value claims, but important ones, there needs to be quick resolution for workers to see justice, not waiting years as well. And unions want to see that too, actually. So.
Brilliant. Thanks for that, Samson. Laura, you may have just dropped off the call and come back on. I'm not sure. But what I was saying is if there's any sort of quick final points around enforcement, now's the time. And then I'm probably going to wrap up the session so we finish at 1:15.
Yes, I did drop off, not intentionally. Yeah, I think it'd be very interesting to see what happens. Great that there's going to be a body that's dealing with issues like holiday pay and sick pay that might not be picked up so easily otherwise, because often they're quite small claims. And I'm
Actually, sorry, Laura, I've just spotted a question that's come in from Catherine
Sure.
Hill, with a particular focus on the enforceability of disability equality law.
okay.
So I'm springing that on you at the last moment, and if it's something which you can't cover, then that's absolutely fine.
Okay.
But I'd give it a tight on time. I thought I'd table it.
Sorry, what is the question? I haven't seen it.
So, can the Fair Work Agency essentially help to strengthen what's currently poor enforceability on disability equality law?
I didn't.
I think, yeah, I think there's a question about a similar one. It might be a different question, but similar one, which is about the enforcement of reasonable adjustments under the Equality Act. So will the Fair Work Agency be getting involved? My understanding is no, and that still falls under the Equalities and Human Rights Commission.
Yeah.
But you might know more on that, Laura.
That's my understanding as well, that it's not within the remit. Yeah, but I think it's going to be interesting to see, particularly with, yeah, good question, with unfair dismissal, with the 6-month period. It may be that we have a reduction potentially in discrimination claims and whistleblowing, because if you haven't got your 2 years qualifying period, it can be quite difficult, even though you've been treated potentially unfairly, to then get that protection otherwise. So I think that there may be swings and roundabouts in terms of an increase in claims, but maybe decrease in particular kinds of claims.
Brilliant. Thanks so much for that, Laura, and for jumping in there, Alice, to try and grab one more audience question. So I think that's going to bring us to the end of the session, as we're running up against time. I hope everyone who's on the call has found it valuable and helpful. We've tried to cover as much ground as we can in what is quite a complex and broad landscape. And I'd like to say a big thank you to all of our contributors today for lending us their wisdom and experience. As I mentioned at the beginning of the session, we are planning to share the slides from the beginning, and that will include some links to additional resources. I have noticed through the course of the conversation in the Q&A tab, a colleague has helpfully been posting some links to gov.co.uk, which have some of those resources in as well. So it's worth looking at those. More broadly, you can keep up to date on the Work Foundation's work in this area via our website and social media channels. We're going to be releasing new insights on aspects of the Employment Rights Act in the coming weeks, and we're planning to run further events on the impact of the Employment Rights Act in 2026. So please do look out for those. Our next online event is going to be focused on tackling youth unemployment in the UK on Thursday, the 26th of February from 2 p.m. And I hope many of you will be able to join us for that. For now, though, thank you once again. I hope you found the discussion valuable, and thank you for joining us, and I hope you enjoy the rest of your day.